Hi, everyone. Thank you for joining us today for Constangy's webinar, State of the State Data Privacy Laws. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. Lastly, we will be providing a recording of the presentation. This will be sent to you once the recording has been uploaded by tomorrow afternoon. I will now turn it over to today's presenters, Jordan Fischer and Sarah Rugnetta.
Hi, good afternoon. Thank you very much for joining us for this State of the State of U.S. Privacy Laws. As you can see from the agenda on the next slide, we're going to do a very brief introduction, and then we're going to dive right into a summary of critical trends that we're seeing in privacy and cybersecurity, focusing particularly attention on some of what we're seeing in the enforcement of these new state data privacy laws. Then we'll provide an overview of the new comprehensive privacy legislation that has either gone into effect in 2023 or that will go into effect in the next few years. And finally, we'll spend some time discussing practical steps on how to address evolving data privacy obligations, strategies that we're working with businesses on to help to improve their compliance posture. In terms of introductions, my name is Sarah Rugnetta. I'm a partner and a vice chair at Constangy Cyber. I have been practicing in the data privacy and cybersecurity space for over 15 years now. I started my career as a regulator. I've worked in-house as a privacy officer. And then for like the last 10 or 15 years, I've been working at law firms, counseling clients on how to navigate these complex and very constantly evolving obligations under state, federal, and international privacy laws. Jordan, I'll let you introduce yourself.
Thanks, Sarah. Hi, everyone, and welcome to the webinar today. Very excited to be going over topics that I think are really hot-hitting news in the privacy space. My name is Jordan Fischer. I'm a partner on the cyber team here at Constangy and work with clients across the globe to address a wide range of privacy, cybersecurity, and technology-related matters. I got my start in privacy clerking on the European Court of Justice in the EU, and since then have really built up my knowledge of various regional approaches to privacy and cybersecurity, as well as working with a number of US-based entities to address what's becoming an incredibly evolutionary and dynamic space within the United States around privacy law. So incredibly excited to be diving into the topics that we have here today. And Sarah, I'll turn it back over to you.
Thanks. Jordan and I are both part of the Constangy Cyber team, as we mentioned, and it's a subset of a larger firm, Constangy, Brooks, Smith, and Profit. We're in the compliance advisory team, which is a group of 15 attorneys and privacy professionals who help clients to proactively manage risk through development of policies, trainings, negotiation of contracts, and lots of other compliance activities. Constangy also has a large incident response team, approximately 30 attorneys who serve as breach coaches for organizations that experience a security incident or a data breach. Our incident response attorneys are available 24 hours a day, 7 days a week to help clients to contain incidents, remediate any harm, and evaluate whether there are legal obligations to notify regulators or consumers. We also have a growing litigation team who assists companies in responding to data privacy litigation, both single plaintiff and class actions, which are unfortunately becoming more prevalent. On the next slide, you'll see some additional information about the Constangy Cyber team, and you'll see our contact information for the breach hotline. Now I'm going to pass it on to Jordan to jump into the next few slides.
Thanks, Sarah. So with this first section, we really want to provide an overview of the data security and privacy landscape. And this is sort of really going to set the scene for understanding the state privacy laws, how they're being interpreted, sort of the focus that the different states are taking. But before we dive into it, it's always important just to recognize that there's a lot of terminology that's thrown around in this space. There's a lot of terminology that's used in news. It's used by different stakeholders across the technology environment. But it's important to understand that not all the terminology necessarily means the same thing or has the same goals attached to it. So we picked out sort of 3 top terms that I think are going to be incredibly relevant. You're going to hear us repeat them throughout our conversations today. But it's data privacy, data security, and technology. Data privacy and data security really can be thought of as 2 sides of sort of, or 2 similar concepts that align, but they do have different goals. Data privacy is really looking at protecting data. It's looking at asking, why do we have this information? Is it lawful that we have this information? And conversely, data security is really looking at the infrastructure that data is sitting in. Are we protecting the access controls? Are we making sure that unauthorized individuals can't gain access to our system? While the data privacy components are incredibly important under data security is much more focused on that technology piece. And that's the third definition that we have here, which is technology, which in our world really can mean a vast amount of different digital assets. It can mean websites, it can mean servers, it can mean cloud environments, it can be your desktop computer, your laptop, your phone, it can be IoT devices. It feels like the concept of technology is continuing to evolve and rapidly change. In fact, as we sit here today, Apple's releasing updates on their own technology. But it's important to recognize that all 3 of these concepts really interchange and are all related. And we need to understand how all 3 relate in order to truly grasp how the laws are being implemented, how the threats are changing in the cybersecurity space, and then how to develop the most impactful and long-lasting strategy for your business around data privacy. So really briefly, I know we're going to be talking mostly about data privacy, but I think it's always important to do a quick update on where the cybersecurity trends are going. So on the next slide, we just have a few key takeaways that we see currently in that cyberspace. So the first is that even though 2022, there was sort of this downward trend in encryption attacks, that has definitely reversed in 2023. And in fact, we've seen a large number of upward trends in 2023 around encryption attacks, cybersecurity attacks generally, business email compromise, credentials surfing, et cetera. A lot of those are sort of evolving out of these supply chain attacks. Log4j, SolarWinds, these are attacks from a few years ago. This year, I think a huge one that we're just seeing across the entire industry is the MOVEit attacks that we're seeing going on. That has impacted, I think the count is over 1,000 companies that have been impacted by MOVEit. It continues to increase in the number of companies that are impacted. We continue to see more and more companies that are coming out with cyber events that are related to MOVEit. So that has definitely been a huge impact on why we're seeing 2023 be this upward trend in cyber attacks. And what does this all mean to a lot of businesses? It's rising costs. And we're seeing those costs from a number of different spaces. So one is just responding to an incident. That response is sort of remediating what's going on, understanding what's going on, but then also any notifications that might come out of that, any litigation that might come out of that. But then also, because we're seeing sort of this vast increase in the number of incidents, we're also seeing more and more companies spend resources pre-incident to try to avoid these incidents happening. So that can be in vendor management, that could be contractual negotiations, that can be in standing up policies and procedures, things that we're going to talk about here. We talk about the strategies of addressing privacy and security, but all of this is sort of just related and is impacting the overall cost that we're seeing from organizations. In addition to these cyber trends, on the next slide, we talk a little bit about some key updates at the federal level. So as we sit here today, there is no generally applicable federal privacy law. There have been a number of discussions, but we are not there yet. We have not seen anything get close to being adopted. And so the state laws, which is what we're going to talk about here in a couple of slides, really dominate the privacy law space. But that does not mean that there's not some movement at the federal level for folks to be aware of when it comes to privacy and security. The Federal Trade Commission, or the FTC, has become this de facto cyber and data privacy federal enforcing agency, even though it does not expressly have a data privacy or cybersecurity mandate. It has become sort of one of the more active federal agencies when it comes to holding companies accountable for cybersecurity and data privacy reasonable best practices. And we have certainly seen, I think in the last 12 to 18 months, the FTC continue this trend of coming out with guidelines for companies, enforcing privacy and security against companies, et cetera. In the same vein, the OCR, which investigates HIPAA violations, so healthcare-related violations, has increasingly been looking at the collection of protected health information via pixel technologies. So there's a lot of pixel lawsuits that we see out there right now around leveraging these tracking technologies, these cookie technologies on websites of healthcare providers that is inadvertently collecting information about patients, visitors to the websites, et cetera. And so we're seeing OCR, the Office of Civil Rights, really be focusing on this data collection through that space and whether it's creating potential ramifications under HIPAA. Additionally, both the government and the private sector have increasingly emphasized cybersecurity preparedness. We've seen at the federal level, both from the White House as well as other agencies, the need for government agencies as well as any private entities that are providing services to government agencies to be maturing their cybersecurity approach, to being proactive in looking for and addressing cybersecurity vulnerabilities. It feels like every 3 to 4 months, we see another initiative be released at the federal level in protecting our infrastructure, whether that's critical infrastructure, whether that's government infrastructure, et cetera. And so we just continue to see that dialogue. And then finally, the EU and the US, in a long saga around the transfer of data from the European Union to the United States, recently adopted what is called the EU-US Privacy Framework, which allows for the free sharing of data between the EU to the United States. This replaced the EU-US Privacy Shield, which was invalidated by the EU courts a few years ago. This is very new. It just came out during the summer. It's something that we're going to continue to watch when it comes to the sharing of information back and forth between these two key regions. But it does demonstrate an additional level of consistency between the EU and the United States, and a recognition that as very strong economic trade partners, we need to have in place some way to transfer data back and forth between the two regions. I want to focus on the next slide just really briefly on what I think is some of the largest news we've seen federally over this past summer, and that is the SEC adopting its cybersecurity risk rules. So this is related to publicly traded companies, but we are seeing companies across the board, whether publicly traded or not, definitely pay attention to these risk rules and what's going to be required of entities. This was passed on July 26th of 2023, and it's the rules on the cybersecurity risk management, strategy, governance, and incident disclosure. There are a number of requirements throughout. We don't have time today to go through it, but I think two key takeaways is that publicly traded companies are going to be required to make periodic disclosures about their cybersecurity risk management, strategy, and governance processes. So it's going to require, not necessarily require that companies be compliant with different aspects of sort of cyber risk management, but basically say you need to disclose if you are in fact doing it. So it's an interesting approach that the SEC is taking around cybersecurity proactive measures. Additionally, another big takeaway is that publicly traded companies are required to provide disclosure about, quote, material and, quote, cybersecurity incidents within 4 days. So it's a very short period of time. The concept of materiality has certainly been one that a lot of people in the industry have been talking about. What does it mean to have a material cybersecurity incident? But this is certainly going to shorten the time period. When these go into effect later this year, we're certainly looking to see how the SEC is going to be enforcing that materiality component, how companies handle that 4-day notification period. It's going to definitely be something to watch. And then finally, again, just looking across the industry and setting this sort of foundation on what's going on, just briefly wanted to highlight some cybersecurity and data privacy litigation trends that we've been seeing. So this is sort of the 4 core areas that we've been watching and sort of the way we can bucket what we're seeing from that litigation context. The first is an uptick in alleged violations under privacy legislation. I would say this is sort of quasi-privacy legislation, quasi-laws that you wouldn't necessarily have originally bucketed in the privacy context, but are being leveraged to sort of create these privacy components to them. So we, of course, are seeing violations under BIPA, the Illinois Biometric Information Privacy Act, that continues to be a real driver of litigation in the space. But we're also seeing litigation under things like TCPA, the Video Privacy Protection Act, and as well as other creative ways of using common law tort claims, et cetera, to hold businesses accountable. So we've seen an uptick in privacy legislation along those lines. We've also seen alleged violations of breach notification statutes. So a lot of class actions that are resulting from data breaches. And the allegations are typically around damages from a failure to secure data or a failure to timely notify, et cetera. So those data breach class action lawsuits continue to evolve and are still incredibly relevant when we look at the litigation trends. And finally, these last 2, the first is single plaintiff lawsuits. So these are lawsuits that are filed by individuals. They have very discrete sort of damage claims that they're bringing. And again, looking at the laws, looking at common law opportunities, the plaintiffs' firms are looking to hold businesses accountable for disclosure, for wire fraud issues, et cetera. And then finally, along the lines of seeing the uptick in the FTC enforcement actions and seeing the SEC get involved and a number of other regulatory agencies start to take a real focus on privacy and security, we're seeing an increase on various privacy and security related matters, an increase in resulting fines coming out of that. And as we see more of these state privacy laws roll out, we certainly expect to see more state attorney generals get involved in data privacy and cybersecurity regulatory investigations and fines. So before we turn to the next section, we have a quick poll question here. Which regulatory agencies are paying more attention to cybersecurity and privacy? We'll give you a couple of minutes to answer that. But in the meantime, I will turn it back over to Sarah to kick us into more discussion around the US state privacy laws.
Great, thanks, Jordan. It's great to keep in mind that there's this backdrop of, federal requirements, international requirements with regard to, some of these laws in other countries as well. Now we're going to shift focus, though, to what we're focusing on during this webinar, which is the state comprehensive data privacy laws that we're seeing come into effect. On this slide, you'll see a map that shows in blue the states that have passed comprehensive data privacy legislation. Maybe I should pause and answer that first question so it's not on our screen anymore. The regulatories that are paying attention to cyber and privacy are all of the above, the last answer. So again, this shows in blue the states that have passed these comprehensive data privacy laws. 4 of the 12 blue states are already in effect. One state, Utah, will come into effect at the end of this year, and then 7 of the other 12 states will go into effect in 2024 and 2025. On the next slide, we'll show a few trends for these data privacy laws, and then we'll dive into a few of the state laws in more detail. So Jordan's going to talk a little bit later about privacy notices and opt-out mechanisms, but I want to highlight quickly a few of the concepts on this page, specifically the 2 concepts at the top of the slide: data minimization and privacy impact assessments. First, data minimization is likely familiar to a lot of the companies who are participating in this webinar that are, particularly if they have obligations under the European Union General Data Protection Regulation, the GDPR. This is a new concept, though, to many companies who previously really focused on just applicable laws in the United States. Prior to the California Consumer Privacy Act, the CCPA, most companies in the US were focused on which types of documents need to be maintained and kept within their organization because of various employment and corporate laws. Data minimization turns that strategy really upside down. Rather than figuring out what they need to retain, what they need to keep, and then implementing policies that prevent destruction, now companies that are subject to these state laws need to figure out how to effectively delete any personal information and sensitive personal information that doesn't serve a legitimate business or legal purpose. And really, given this, the very expansive definition under personal information in these various state laws, which is basically any information that can be linked to an individual, this process can be extremely onerous, and a lot of companies are spending a significant amount of time really looking at and developing a data retention and destruction process that is going to minimize data. I also want to draw your attention to privacy impact assessments. This is another concept that emanated from the EU GDPR. Some of the new laws that we'll talk about today require companies to conduct and to document an assessment of processing activities that present a heightened risk of harm to consumers. We're waiting on final regulations that will provide a little bit more insight into the specific types of activities that will trigger this requirement. But we do anticipate that many businesses will need to start incorporating assessments into their privacy programs. For example, companies that process personal information or sensitive personal information that use things like artificial intelligence will likely need to conduct an assessment, because under some of these state laws, we anticipate that AI will be considered a high risk, presents a heightened risk of harm to consumers. On the next slide, this is the list of 5 states that have data privacy laws, that have enacted privacy laws that either went into effect in 2023 or in the case of Utah, will go into effect at the end of this year, at the end of 2023. I should note that in California, the CCPA, the California Consumer Privacy Act, did go into effect a couple of years ago, but in 2023, the law was significantly expanded with the CPRA, the California Privacy Rights Act, which became effective in January of this year. The first question that every company really needs to ask is, do I need to comply with these laws? California's applicability thresholds are the most expansive because they include a revenue threshold of $25 million annual revenue. And this really brings a lot of companies into the fold, even if they're not collecting or processing a significant volume of personal information about California residents. The CCPA also does have data volume-based thresholds if you don't meet that revenue threshold, and also looks at how much revenue companies are making from selling personal information as well. So there's a couple of different thresholds, but really that revenue threshold makes California very expansive and does bring a lot of companies within the scope of the law. California also applies to employee data, which is unique to California. Most states carve out employee data. Every law does have a different applicability threshold. Most focus on volume of personal information processed about that state's residents, or the revenue that's, like I said, the company derives from selling personal information. It's really important to carefully review the language of each law. We'll talk a little bit about some of these exemptions that might apply to your company as well on the next slide. But every state has different requirements in terms of consumer disclosures and requirements about internal policies that need to be implemented, external disclosures, consumer rights. So it does make sense to really start by looking at what applies to you. On the next slide, We'll look at a snapshot of the laws that will come into effect in the next 2 years, in the next 3 years. July 1st is a big date where we'll see 3 new laws that will come into effect. Montana will come into effect later in 2024, and then 2 states in 2025, and finally Indiana in 2026. I'll make a prediction. I don't think it's a very risky prediction that this particular slide is going to change significantly, probably even in the next couple of months. We already know that Delaware will be added soon to this slide. That law is awaiting signature by the governor. There's also
actually, Sarah,
few additional. Oh, yeah.
Sarah, just to interject, the governor of Delaware signed today. So we actually have hot-hitting news.
Breaking
the governor
news.
of Delaware signed. Yes.
I did not see that yet. Thank you, Jordan. So, okay, well, I guess this slide is already outdated. So we'll be updating it later today, not later this month or next month. And then there's also another, quite a few other legislative bills that are at varying stages of the legislative process. So again, even certainly Delaware has already changed this slide, but I think we'll see some additional changes as well. The next few slides highlight a few differences and nuances between the state laws. This slide depicts some differences around exemptions that need to be carefully considered when you're deciding whether the law applies to you. I did see a comment come in about nonprofits. Under many of these state laws, nonprofits have been exempted from applicability and nonprofits are out of scope. Although in each state, you really have to look pretty closely at that exemption because there are nuances that require sort of looking at affiliated entities and whether there's common branding. But for the most part, nonprofits that are truly nonprofits and not affiliated with a for-profit are exempt, with the exception of Colorado, which has exempted nonprofits. Another thing to really look closely at is whether your organization falls within one of these other exemptions. For example, you'll see circles and then some check marks, and I should probably explain what those mean. Basically, the circle demonstrates that the state has a data-specific exemption, and the check mark shows entity-level exemptions. And I think the first column demonstrates this a little bit. Some states have enacted exemptions for protected health information that's regulated under HIPAA, but then other states like Connecticut, Utah, and Virginia have exempted more entity-wide exemptions for covered entities more generally that would apply to their employee data and other types of data that they're collecting from websites and other places. Similarly, the Gramm-Leach-Bliley Act, FERPA for higher education, government entities, and then employee data are different categories of exemptions. And I've already mentioned, I think that California is one of the few laws that apply to employee data. So that really was a big change this year. The next slide shows a few additional differences between the state laws regarding requirements related to privacy impact assessments, audits in California, and contractual requirements. In California, we're still waiting on regulations that detail what exactly those audit requirements will entail and who it applies to. We anticipate that those will be released in draft form, at least in November or December. And this is based on some statements that were made last week during the PPA, the agency's board meeting. With regard to contractual requirements, we recommend that all businesses that have obligations under any of these states look really closely and dust off those template contracts with service providers to confirm that they contain required language around data processing, because it really does make a significant impact on whether that business is, whether disclosing information to that business constitutes sale of information, especially in California, and is relevant to some of the disclosures in the privacy policies. On the next slide, you'll see some differences regarding, on the next slide, we have a poll question. Which state has not passed a comprehensive data privacy law? We have Vermont, Utah, Virginia, and Iowa. Give you a minute and then just let you know that that is Vermont. The other 3 states listed on this slide have passed data privacy laws. Okay, great. And then next slide. You'll see that there are some differences regarding penalty structures in the different states. California is significant in that it does include a limited private right of action. In California, this will apply in the event that a business has a data breach and they're not complying with the CCPA. But in all of the states, regulators have authority to issue fines. The amount varies by state, but regulators do have quite a bit of discretion on how to calculate those fines. Generally, they're per violation, but they can be interpreted in terms of violations per day or per consumer. I'm going to pass this off now to Jordan, who will review slides on data subject rights and consent requirements.
Perfect. Thank you, Sarah. So the next few slides, we're going to dive deeply into some of the various requirements that you see across these different U.S. state privacy laws. I think it's important to recognize that there is a lot of commonality amongst these state laws, but where I think it's important to dial in is where there's nuances. And the key when you're developing your privacy strategy and approach to the US state privacy laws is to find a balance between creating a consistent approach that the teams can leverage across these different state privacy laws, but then creating the mechanism to recognize when there might be this unique difference in one law or sort of a unique area in another law, where you need to be able to tweak and modify to meet those different jurisdictional requirements. So that being said, pretty much across all of these US state privacy laws, there's some form of data subject rights. And basically what these are is they give the end consumer, so the individual whose data it is that is being collected, a rights around that data. And oftentimes it's those rights to know what information has been collected. So a lot of these transparency rights, a right to access the information that you may have collected on the individual, a right to delete information. Now, pretty consistently, these states do not make this an absolute right to delete information. So if it's required that you maintain this information or keep it for a period of time, that right to delete is not going to trump those other requirements, but that's going to require sort of digging into why you have the information, why are you required to keep it, et cetera. A lot of these state laws are also focusing on this concepts or these data rights around restricting the sale or sharing of information. And we're going to talk about that in the opt-out context in a couple of slides. But pretty much the key to understanding a lot of these data subject rights is, one, to what extent does this right really impact my business? Am I going to have consumer information? Am I going to be consumer facing such that I'm going to be the entity that's responding to these rights? If I'm going to be responding to these rights, where is the data housed in my system? Sarah and I often talk about conducting data mapping or data inventories to make sure that you understand what information do you have, why do you have it, so that you can proactively prepare to respond to these rights. Because as I said, pretty consistently across the US states, and frankly, even internationally, we're seeing these data rights be incorporated into these laws and be candidly one of the fastest ways for individuals to complain about companies to regulators. So it's an area that I think has a high risk because it's outward facing, and you want to make sure you develop a strong process to address these rights. And on the next slide, we've sort of broken down what, as we see it, sort of these 5 core steps to responding to a data subject right request. And I want to just highlight that while it seems simplistic when you look at it on a slide like this can sometimes really be a challenging exercise for your team to run, especially those first 1, 2, 3, 4, 5 times that you're going to be running through this exercise. But here are sort of the core 5 steps that you want to be thinking about when you're building out your process to responding to data subject rights. The first is that many of these laws expressly require that a business confirm receipt of the request from the consumer. So, and I think California, you have to confirm within 10 days. There's specific timelines associated with that under different laws. But the first step is confirming we've received it. We have a copy of it. We're looking into it. We're going to get back to you on that. The second step is conducting a review for the data. Do you even have information about this individual? If you don't have information about this individual, great. You can respond. We don't have that information. You can move on. But in order to make that response, you need to review your systems. It can be on-prem systems, it can be cloud-based databases, it can be paper documents, it can be electronic documents, but you need to have a process to really systematically look at your entire infrastructure, where this data could be stored, and review your systems for that data. The next step is you need to conduct a review of any service providers or any third parties who you may have given this data to. Because when a request comes into you, it's not only reviewing your infrastructure and your systems, but it's also looking at anyone that you might have given a copy of that data to, because you may have to direct that they do something in light of the request that you've received. Step 4 is compiling all of that information. And I want to emphasize, this doesn't mean you're necessarily going to give the consumer everything that you've learned, all the information that you've gathered. But in order for you to make a knowledgeable determination as to how you're going to respond to a data subject request, you need to have a global picture of what it is that you're dealing with. If you don't have data, if you only have pieces of data, if your data is not kept in an identifiable format such that you can't confirm that this data relates to the consumer who actually made the request, et cetera, all of that's going to be super relevant to allow for you to make an informed decision as to how you want to respond. And then finally, responding to that request. Again, the regulations often have a specific time period that you have to respond. California has a 45-day time period to respond substantively to the request. There are exceptions that allow for you to take a longer period of time, but generally, we typically advise try to stay within that initial time period, because anything longer than that, the burden is going to be on the business to demonstrate why it needed the additional time to comply with that request. So again, there's a lot of nuances, a lot of steps in between all of these different areas, but this is generally a good starting point when you're looking at building out your process for responding to data subject right requests. Look at these 5 core steps and start to build out what works within your infrastructure. On the next slide, I want to dive into what I think is a very challenging concept, which is consent. Many of these regulations have some aspect of consumer consent built into them. The idea being that a consumer needs to consent to the collection of information, can withdraw consent to the collection of information, that a consumer has to be informed in order to make that decision around consent, et cetera. So there's a lot of these concepts of consent built across a lot of these different laws. When you're looking at consent, there's really 2 forms of consent that we're dealing with in the privacy space. The first is opt-in, meaning there's an express, affirmative, or explicit consent. So this means that if someone's going to collect my information, whether that's online or in a different context, I'm affirmatively saying, yes, you can collect my information. You're not presuming that you can collect my information. On the flip side, we have opt-out consent. And opt-out consent is usually where we can assume that we can collect information unless a user has expressly opted out of the collection of their information. So when we're looking at consent, those are really sort of 2 formats that we're generally using. And the United States, for the most part, generally aligns with opt-out consent. Now, that is not across the board when we're dealing with things like health information or sensitive personal information, biometrics. Some of our laws flip and leverage an opt-in consent mechanism. But for the most part, for the general consumer information that might be collected, opt-out consent is what we're dealing with. And if we go to the next slide, we just have one example we can share with you specific to Colorado, the law that went into effect July 1st of this year. And it defines consent as a clear, affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement. right? So this is saying it has to be clear, affirmative action, there's some type of agreement in place. It does not include acceptance of a general or broad terms of use or similar documents. So just generally agreeing to a terms of service or a privacy policy, not going to be sufficient to demonstrate express this consent that's required under Colorado. It does not include hovering over, muting, pausing, or closing a piece of content. And it also does not include agreement obtained through dark patterns. And dark patterns is this term that we've heard a lot in the technology space. The FTC has started leveraging it, but basically it's trying to, without being incredibly transparent, sort of push users to one direction or another. In a way that's not very transparent or clear or fair to the end user. So here's an example of what we see in consent in Colorado. A lot of the state privacy laws are using very similar terminology. We're starting to see this trend of expressly saying consent does not include and list out a number of items similar to what we see here in Colorado. So again, it's important to be looking at the law itself to determining, is there something different about consent that I need to be aware of? And if that is, what exactly is it going to be required of me? On the next slide, I want to highlight some of the online data collection opt-outs that we see. This is an area that I think both from a regulatory compliance perspective as well as a litigation perspective, we continue to see a lot of movement, a lot of focus from the regulators. A lot of that focuses on things called cookies and tracking technologies. Both of these are technologies that are placed on websites to either save information about a user, collect information about visitors, track visitors, whether within the given website or sort of across the internet more generally. And the trend that we're seeing is that a lot of state laws are requiring that companies provide global opt-out opportunities, such that every time you go to a website, you don't have to opt out of the collection of your data through tracking technologies or cookies. You've set up this global or universal opt-out, a global privacy control that basically says you can't collect my information. I've already opted out of it. Most of these global privacy controls and these universal opt-outs are not going to be in effect until about a year from now, if not further down the road. So companies do have time to come into compliance. They are often at the browser level, and companies need to develop the technology to recognize at the browser level when an individual has set up a universal opt-out or a global privacy control to say you cannot collect my information. So basically, it's a proactive opting out of any collection of information. Additionally, and this is something that I think is very unique to the United States, is this concept of the selling or sharing of data and the ability of consumers to restrict the selling or sharing of data, either directly to the business that they're interacting with or downstream to third-party businesses. I'm going to talk about that in a couple of slides, but if we go to the next slide, you can sort of see here that we've a lot of times when we're dealing with online data collection, online tracking technologies, the way that businesses have been addressing that to either provide the ability to opt out of the collection or to use an opt-in consent is through the use of cookie notices. And again, the global privacy control, the universal opt-out, this will in a lot of ways negate the need for a cookie notice, because if a user has already opted out of the collection, you would need to be able to recognize that and they would not receive a cookie notice. But for users that are not doing a global opt-out, cookie notices will still be relevant. And in short, a cookie banner should include a notification that cookies are being used, notification of what information is being collected with those cookies, and then the option to accept, reject all, or learn more about the collection of the cookies. So this is that opt-in, opt-out concept. In the United States, the default can be that cookies are placed on a user's browser and starts collecting information until the user opts out. That's the exact inverse of what we see internationally, and specifically in the EU. You can't place cookies on a user's device until they've expressly opted in. So it is really important to be looking at the jurisdictional differences when we're dealing with things like cookie notices, collection of information, tracking technologies, because we are seeing a divergent approach internationally than what we're seeing under these US state privacy laws. And then finally, on the next slide, I just want to highlight sort of this is a snapshot of what we're seeing when it comes to these opt-out requirements under the US state privacy laws. Right now, California is the only state that we're seeing really focus on this concept of the opt-out of sharing information. So this is when there's no exchange per se of monetary consideration. It's not quote unquote the selling of data, but just the sharing alone of information. We need to be able to provide users with the ability to opt out of the sharing. Across all of the laws that have gone into effect this year or will go into effect this year, users need to be provided with the ability to opt out of the selling of information. And it's really important to look at how each state is defining that term of selling information, because it can be very nuanced when you look at California versus Colorado, et cetera. Additionally, many of the states, actually all of the states except for California, also are requiring an opt-out of targeted advertising. So this is where information collected about the individual is used to specifically target them with ads. This is not generally applicable advertising that just is going on someone's, LinkedIn or on their website or any of their browsing. This is specifically targeted to that individual using some form of information that's either been collected by you specifically or by a third party that's leveraging that data on your behalf to target the individual. So in Colorado, Connecticut, Utah, and Virginia, individuals need to opt out of targeted advertising and be given that option to opt out. And then finally, California, Colorado, and Connecticut, those are the three states that are going to require these universal opt-out mechanisms. California calls it the global privacy control, but it's very similar to what the other states are saying as a universal opt-out mechanism. These are mostly going into effect in the next year or so. So there is some time for the technology teams to develop solutions to recognize these global opt-outs. But it is something that's going to be coming and be required that businesses be able to address them across their websites and allow users to leverage those universal opt-out mechanisms. So on the next slide, we have our final poll question. And it is the US generally follows an opt-in regime for non-sensitive personal information, yes or no? Give you a second to answer. And the answer is no. So we can go on to the next slide. Hopefully that was an easy one for everyone to get. And then finally, I just wanted to highlight, Sarah already did a great job of talking about these data protection impact assessments. They are generally starting to be required across most of these state privacy laws. Similar to setting up a process to address the data subject rights, there are some clear processes that you can put in place to adopt a data protection impact assessment process and procedure, and then make sure that your teams are doing this when required under the law. So typically the objective of a DPIA, if you've never done one before, is to identify the potential risks and effects of collecting, maintaining, and disseminating personal information. So really the goal is to say, are we creating any privacy risks by the nature of us collecting and using this information? Each state maintains its own list of events that may trigger a DPIA. There is some commonality amongst those, but there are some nuanced sort of one-offs that are for each state. So you should be articulating within your process the states that are applicable to you and which ones have different triggering events. The third step is to identify risks. So look through and really look at, are we creating risks to individuals? Are we creating compliance risks? Do we have corporate risks, financial risks by collecting this information? Is it highly sensitive data that if breached could create a high risk for our organization? Really looking at the process around the collection and use of that information and understanding the various risks that may result out of that information. And then finally, to the extent possible, mitigating that risk. And that could be not collecting the information. It can be collecting it in a different format. It can be encrypting the data, or you might have to accept risk, because if you need to collect information in order to run your business, the laws aren't saying don't collect it. It's just understanding that by collecting it, you might have these additional risks that attach to it that require you to take some more proactive measures. So that was sort of an overview of some of the more specific areas under the laws that are required to comply with. And I'm going to turn it back over to Sarah to talk a little bit about the strategies for addressing these privacy laws.
Thanks, Jordan. Before we dive into strategies, I just want to quickly address one of the comments that came in. There was a question about the definition and scope of consumer, and I think that's a really great question and something I want to clarify quickly. Most of the state laws have specifically exempted employees, so individuals acting in any employment context or in the commercial context, so that business to business data. Of course, there's one state in particular that does not follow that general rule, and that's California. As of January 1st of this year, when the CPRA came into effect, employee and business to business data businesses do have to comply with all of the CCPA requirements for employment and business to business data. So that's a really important thing to consider. And one thing I want to highlight in terms of this slide, which is sort of privacy strategies, especially now that we understand some of the nuances and consistencies between the states. And that's, how to sort of, now that we understand a little bit about what's required under these different laws and where there's some differences and where there's some commonalities, sort of how to just tackle this and develop a privacy strategy. Many companies are looking at some of the most stringent requirements, especially those emanating out of California, and looking at consistencies across the states and trying to align their privacy program to those requirements on a more organization-wide standpoint. So for example, employee data, you do need to provide certain disclosures to employees in California and applicants in California. Oftentimes, many companies are just going to apply that across the organization, even to employees who are living and residing in other states. Applicants, notices to applicants presents sort of an interesting dynamic, because oftentimes it's not possible through even IP addresses because of VPN to determine where an applicant is submitting their application from, where they're residing, which means that a lot of organizations have just decided that they're going to provide certain disclosures to applicants across the board. So I think that's just one example of where companies are trying to think strategically about how to actually implement some of these data privacy requirements, recognizing that there are a lot of consistencies, but also quite a few nuances in different states. So you also need to take those into consideration. I think the first step is always to understanding what laws apply to you and thinking about the type of services that you're providing, the type of data processing that you're doing, how information is coming into your organization, and how you're sharing and disclosing it with third parties and service providers. When you also want to think about the volume of data that's processed in each state and whether those states apply to you. If you're a nonprofit, for example, you're really going to be focused more on Colorado, and you might be able to not focus nearly as much on some of those other states, because Colorado is an anomaly in that they do apply that law to nonprofits. On the next slide, we really get into a couple of the steps that we recommend companies consider as they decide how to tackle privacy in light of these new requirements. And the first one really is to, again, assess what laws apply to your company by looking really closely at those different thresholds that apply for each state, as well as the exemptions, some of which we covered today. Then after you perform that assessment, review your current policies, documentation, and contracts, and perform a gap analysis. Many of your existing policies and procedures and forward-facing disclosures are likely going to address some, but not all of the state law requirements. So understanding what you currently have in place is a perfect starting point, and identifying where those gaps are so that you can kind of manage this in a more reasonable fashion and not just try to sort of scrap everything and start over. And then the third is really privacy remediation, looking at those identified gaps and developing a plan that prioritizes how to address the gaps. Generally, we recommend prioritizing the gaps, well, I guess first in terms of when the law comes into effect that applies to you, of course, but then looking at taking a risk-based approach. Which gaps really present the biggest risk to your organization, and obviously kind of developing a risk mitigation plan that tackles those first. A couple of areas that I think are great starting points are forward-facing disclosures, for example, to applicants and employees in California, and in those privacy policies and just-in-time notices, sort of more generally, in terms of your forward-facing websites, are a great place to start. There's probably, if you haven't dusted those off in the last year or two, I anticipate that you are going to have to add additional disclosures around consumer rights and different disclosures about how you are collecting, processing, and disclosing personal information and sensitive personal information. Another area that we believe is pretty high risk and something that a lot of companies should take a close look at are updating their contracts to make sure that you are disclosing or including a number of provisions that are required in different states around how you're processing data, data ownership, how data can be used and potentially aggregated by service providers, and restrictions otherwise around that data use. And then, of course, the final step is developing new policies, updating those disclosures, updating contracts, conducting training, and otherwise just implementing the program and updating it as needed over time. I'll pass this to Jordan to talk about the next couple of slides.
Thanks. And just, two final points here, I think, to sort of emphasize when you're strategically laying out your plan for addressing privacy. The first one is you really need to understand your data. Not all data is created equal. Your role in the data ecosystem is going to be really important to understand. Are you a service provider? Are you the entity that's actually collecting the data, and sort of who's the business or the controller, depending on the regulation of sort of what your role might be called? Because all of that is going to dictate what you're required to do under the regulations, how you're going to implement the privacy program, how you're going to address data subject rights, regulatory requirements, et cetera. So understanding your data, mapping it across your organization, whether it's protected health information, biometric information, personal information, protected, personally identifiable information, this sort of term of art that we see in the cyber breach notification context. All of that's going to be incredibly useful because you're going to use that to then understand how you need to address these laws, which processes are going to be more relevant to your organization. And if we look at the next slide, just wanted to highlight some best practices that Sarah and I have seen in working with organizations that we think you can really take with you after the webinar today. So as I said, understanding your data, mapping that data to impacted regulations and the legal requirements, that's really going to be a key part of building out your solution. Creating an effective strategy. I think the biggest thing is be reasonable and realistic. If your organization does not even know or understand what privacy is, you're not going to build out an incredibly mature, robust program in the next 3 months. I think it's creating an effective plan to build that program that works for your organization, that addresses your higher risk areas, and just continues to mature the approach over the coming months and years. That's going to be the best way to address these changing and evolving privacy requirements at the US state level. And then finally, customizing the solution for your business. Not every business is going to approach privacy the same way. Not every business has the same technology. Not every business has the same culture around data. And so I think creating an infrastructure that's going to work for you, that's going to allow you to have a very strong baseline of privacy that you can then build off of as we get more state privacy laws that come into effect, as we see developments at the federal level, and then as we sort of see the international landscape change as well. That's going to be a real key for a successful approach to privacy in the long term. So focusing on where can I create that framework that grab those areas of consistency across all these different state privacy laws. And then how do I recognize where there might be nuances, where there might be these differences that are really important for my business, and making sure that my team is trained, understands what's required of them, and can continue to grow and evolve the privacy program. So I know that we're up on time here. Really appreciate everyone joining us today. I hope it was informative. We know this space is constantly evolving and changing. We welcome you reaching out to us with any questions that you might have. Follow our blog at constangy.com, and we will make sure to share this presentation with everyone sometime in the next few days, but appreciate everyone joining us today. Thank you.